Drafting an ERP implementation contract is one of the key factors in mitigating the likelihood of an ERP implementation failure. What should you ask for and what is reasonable? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For the last 20 years, I've devoted my practice to drafting and negotiating ERP-related contracts and litigating failed ERP implementation projects in courts across the country. An ERP implementation agreement goes by many names, whether you call it a professional services agreement, a master services agreement, or a consulting agreement. It really doesn't matter. It's one of the key components of the contract package that you're going to negotiate. Some of the key provisions that you need to focus on really have to do with the scope of the services that are going to be provided. What consulting services are at issue? Is there going to be a statement of work that is going to detail exactly what is going to be provided, when it is going to be provided, and how it's going to be provided? There should be. You need to have an understanding, and the contract should detail where those services are going to be provided. Is it going to be provided on site? Are the services going to be provided remotely? Is it going to be sort of a hybrid approach? Are the consultants going to be located offshore? All of that needs to be detailed with a pretty high level of specificity in the agreement. You want to incorporate a detailed project plan, and that is typically going to be a document that really gets into the nuts and bolts of the implementation, the deliverables, the milestones, who's going to do what and when it is going to occur. And that is typically not a contractual document. So what you will need to do is incorporate that document by reference in the body of either the statement of work or the implementation contract itself, so that if there is a failure to comply with that document by the vendor, you've got some sort of contractual remedy and you can really hold their feet to the fire. You want to carefully define milestones, deliverables, deadlines. All of those need to be defined either in the statement of work or the body of the agreement, depending on the nature of the engagement. But you have to have an understanding of when those things are going to be provided to you, who is going to be providing them, who's responsible for providing them, and when they are going to happen. You want to have detailed acceptance testing criteria for deliverables, for modules, for functionality, whatever it is. There needs to be a process by which you can review those, make sure that they comply with whatever mutually agreed upon specifications are applicable to those deliverables. And more importantly, there needs to be a process for rejecting those deliverables that are non-conforming and then obligating the vendor to provide them to you again. And if they can't, you should negotiate some sort of a remedy, whether that is a refund, whether that is termination of the contract, or some sort of a credit. Whatever it is, it needs to be in the agreement. You want to have implementation-specific services warranties, and these are going to be warranties that are going to be different from the warranties associated with the actual software product. And you're going to want to have a warranty that obligates the vendor to provide services in a professional manner, in a timely manner, in accordance with generally accepted industry standards. There's a variety of ways to do this, but there's got to be some sort of objective standard by which you can hold that vendor's feet to the fire. And more importantly, if there is a breach of that warranty, you want to have some sort of substantive remedy, and typically that is going to be some sort of a reperformance obligation. And if the services cannot be reperformed in accordance with the contractual obligations, then you want to have some sort of a credit or some sort of a refund of the money that you paid for those services. You want to ensure that you've got some sort of dispute resolution process, and this can be language that would obligate both parties to have a meeting of the minds and come together in good faith to resolve problems with the implementation project that arise. It can be informal, it can be formal. You could have a mandatory mediation process before things get escalated to arbitration or to litigation. Whatever the process is, it's usually helpful to have some sort of mechanism in the contract that obligates the parties to work together to resolve an issue. You want to consider including language in the implementation agreement that allows you to approve or reject certain consultants that are assigned to your project. So for example, if you have an incompetent consultant that is being assigned to your project that doesn't understand the functionality of the software, doesn't understand your business, is falling asleep at meetings, is not fully engaged in the process, you want to have a mechanism within the contract to get that guy out of there and to have some replacement come in to get the project on the right track. I think if you focus on these issues when you're drafting and negotiating your implementation agreement, you're really going to set yourself up for success. If you have any questions about any of the issues discussed in this video, please feel free to reach out to us at taftlaw.com. We'd love to talk to you and love to set you in the right direction. Factor in mitigating the success. It's not mitigating success, it's mitigating the risk of failure. Okay.